with those things tilted back like that, or the background, it's like tilted back a little bit.
You can't tell on the close-up. On the wide, you can tell a little bit. It's tilted back a little.
Okay. The rings. Oh, yeah. Okay. In the blinds or in the?
Yeah, the blinds behind the backdrop.
There are blinds there.
Yeah, that one.
You can't cover that though.
Yeah, I don't think there's
Where
any
the
that one.
mezzanine wall goes.
Okay. Okay.
And then moving it along.
Whoever designed this room and caused all that part to happen should be fired.
Oh, then we'll do that one.
Let's put a 2-foot counter.
Well, that's where the divider wall goes. So you can't put blinds there, or they will be squished in. I mean, you could put two sections this wide. You would eliminate it. You would just minimize it. Of course, there's a 5-inch gap between all of them. So just put that and be over that way.
That's literally the only use to it.
You want to put it on the outside.
Do that.
One speed.
Whose attention are you trying to get? Like you just want to see
I'm
this?
gonna
Good afternoon. I want to welcome you all to our afternoon panel on Constitution Day 2024. Constitution Day, as you all know, September 17th every year, is a celebration of the day that the delegates to the Constitutional Convention in 1787 signed that document and sent our founding charter out to be ratified. And we celebrate Constitution Day on college campuses every year because about 20 years ago, Congress said that this would be a good idea. Universities are responsible for educating our citizenry, and particularly our civic leaders, who disproportionately turn out to be college students. And so we should spend some time every year remembering what's important about our Constitution, remembering something of our constitutional history, and doing the work of civically equipping the young citizens we have in our institutions. This year, we've been focused today for UVU's Constitution Day commemoration on questions of partisanship in the Constitution. This morning, we had a wonderful keynote from Verlin and Hiram Lewis about the myth of left and right, how those paradigms of a political left and a political right tend to distort political reality and lead citizens to be more polarized and divided than they otherwise ought to be, and get in the way of constitutional stability. This afternoon, we're going to turn and consider a really crucial issue that's percolating in Utah politics right now, but really pervades American constitutionalism at the state level, and that is the question of citizen initiatives, direct democracy initiatives, and their relationship to our political institutions, our representative institutions like our legislatures. Joining me this afternoon for this panel, I've actually got a range of distinguished members of our community, some of whom have been engaged publicly in this debate, so that we can have an open conversation, so that instead of scaring citizens over this, we can try to educate them so that we as a community can make an informed choice about the best way to go about changing our laws and doing Republican government together. I'm Matthew Brogdon with the Center for Constitutional Studies. I'm the senior director here, and I'm privileged to lead this institution. Joining me on the panel, just to my left, is Ryan Bell. Ryan is a partner at a Salt Lake law firm, Kunzler, Bean, and Adamson. He's also on the board of Better Boundaries Utah, which has been extensively involved in the ballot initiative that gave rise to our current controversies over initiatives, and has since been involved in the litigation and legislative action on that issue. To his left is Savannah Eccles Johnston. Savannah is a colleague. She is a professor at Salt Lake Community College in political science. She is also a Civic Thought Leadership non-resident fellow with the Center for Constitutional Studies. And starting later this month, my co-host on the podcast, This Constitution, a podcast for every American on their founding document. So be looking for that on your favorite platform. And finally, I have Derek Monson. Derek is a vice president at the Sutherland Institute and a regular contributor to things that we do in the Center for Constitutional Studies. And like Better Boundaries, Sutherland has been actively involved in the legislative action and the controversy over Amendment D. So as you can see, we've got a range of perspectives on the panel, and our hope is to give people a sense of what the status quo is on this issue, just exactly what has occurred with respect to ballot initiatives in Utah, what is likely to happen here in the near future so that people understand the situation we're in and can understand the consequences of the choices that we're making in the legislature, in the Supreme Court, and in public in the upcoming election. And then also to get into the question of direct democracy versus representative democracy. I'll say at the outset of the panel that one of the great challenges for an institution like the Center for Constitutional Studies, one of the great maladies that we're seeking to remedy, is an eroding trust in our institutions. Increasingly, Americans do not trust their institutions of government. That includes at the national level with Congress and the presidency, our political parties. We have declining trust in other institutions in our civil society that don't directly wield political power but play an important role, like universities and the professional press. These are institutions that have been the machinery through which we engage in self-government and through which we inform ourselves about the world, through which we learn and inquire into questions together in universities, and through which we seek to govern through representative institutions. And with trust eroding in all of those institutions in our society, it's a very important question whether we ought to and are benefited by resorting to direct democracy, that is, having the people themselves craft laws and vote on them without the involvement of deliberative institutions like a legislature, or whether we need to retain or reserve more role for our representative institutions and avoid direct democracy. That's a really quite pressing question for us. So I'm actually going to start at the local level here. We'll start with the particular and talk about what's going on with the ballot initiative process in Utah. So Ryan, why don't I start with you? Would you help me understand what was the status quo before the Supreme Court's decision back in August with respect to ballot initiatives? How did they work, and what was the legislature's role and authority with respect to them?
Well, okay, thank you. And I'm grateful to be here. Thanks for having me. It's interesting because you're going to hear disagreement about what the status quo was. There are those who would say the Supreme Court came in and let us all know how it has operated for the last 100+ years. There are others who will say, actually, this represents a fairly radical departure from where we had it. I'll give you my view of what I can historically and try to be objective. Back in 1900, not long after the state was founded, our state became the second state to pass a constitutional amendment allowing initiatives and referenda, i.e. direct action by the people, to pass legislation. There were several decades where nothing really got off the ground, and that's because the legislature didn't pass enabling legislation to allow that to take place. Around 1960 is when we got our first initiative passed. Since then, there have been a total of 7 initiatives passed in Utah. In other words, it's quite hard and it's extremely rare for Utahns to get all of the wherewithal and the public will around getting an initiative passed. However, this all came to a head in 2018 when Better Boundaries, my organization, and some other allied organizations decided one thing we're really concerned about is gerrymandering. We want fairer election districts. And so they worked together, had a fairly collaborative process, and they got an initiative on the ballot that would make it more difficult for legislative districts, both state and federal, to be gerrymandered, i.e. they enacted some principles that should guide the drawing of election maps. Soon after that, the legislature looked at the initiative, said, actually, no, thanks for trying, and they amended, some would say repealed, but amended or repealed that initiative, and essentially said, you're free to do what you want, redistricting commission, but we will be the ones who have final say, and we don't have to give reasoned answers about why we draw these. That resulted in a new set of what I think is fair to call fairly gerrymandered legislative maps, where, and you can look at pictures of these online, you'll see that our current federal congressional districts, they all meet up in a neighborhood in Salt Lake City, which has the effect of minimizing and diminishing the voice of those who lean a little bit more liberal in the city and kind of cracks them into other districts. So that was that status quo. Better Boundaries, allied with a few other organizations, leading to a lawsuit, which resulted in this Supreme Court decision that took place in July.
That's excellent. Thank you very much. Derek, if I could ask you, what did you take to be the legislature's authority over ballot initiatives before this occurred? And then what is it that the Supreme Court did to alter, if in fact they did alter, that dynamic or that status of initiatives?
Yeah, thank you. I think prior to July or August, when the Supreme Court ruling came out, I think it was generally kind of viewed that both methods of enacting laws were kind of on similar legal terms. One was the people voting themselves, the other was representatives of the people voting on laws, and they would be treated more or less equally. Anything that passed through the legislature could be repealed the next year. Things that passed through ballot initiative could be repealed or amended, or it's just kind of the same kind of rules applied. And with the Supreme Court ruling, it became clear that the rules are a little different with ballot initiatives. That's kind of what they set up. That in certain circumstances, they put some limits on it, that you cannot repeal, the representative democracy functions cannot repeal ballot initiatives or significantly amend them. And so that was a change. And I think, even if, whether or not you agree with that, I think it's clear when you look at the history, that was a change. Now, there might be some people who presumably people who initiated a lawsuit who thought that's how it should be. That's just not how it had operated up to that point, is all. And so that created a new way of thinking about how we enact laws. Do we have laws that are kind of protected from other laws? Do we have processes of the power of the people that are protected from other processes of the power of the people? And that gets really difficult to figure out what the law should be and how we're going to decide these things. it draws the courts into it a lot more. And I think that's where a lot of the controversy is coming from, right? The folks who would like to not see the courts deciding on these things versus those who are more comfortable with that. And there's other ways to demarcate, I think, the differences of opinion, but that's one of them.
So I'm going to read the constitutional provision that the Supreme Court used in the litigation, which was League of Women Voters versus the legislature. The passage says this. This is Article 1, Section 2 of the Utah State Constitution, which if you find yourself lacking a copy of the Utah State Constitution, the Center for Constitutional Studies can offer you a pocket version of it. Says all political power is inherent in the people, and all free governments are founded on their authority for their equal protection and benefit. And, this is the key phrase that the Supreme Court utilized, they have the right to alter or reform their government as the public welfare may require, period. So the Supreme Court utilized this language to say certain kinds of ballot initiatives are not just ordinary law that the legislature can subsequently alter or repeal. Savannah, I thought I might get you to chime in at this point. The Supreme Court's the Supreme Court's decision with respect to how this process works, how did that change the situation? That is, what do we have now in terms of the status quo, in terms of which ballot initiatives the legislature gets to tinker with after the fact, repeal, amend, change, and which ones are beyond the reach of the legislature?
Well, again, I think it depends on how you view the history of initiatives in the state of Utah, if this is actually a significant departure from what was previously done. But now, if you get an initiative passed in the state of Utah, let's say an anti-gerrymandering initiative, and it goes to the state legislature, they cannot tinker with it so as to fundamentally alter its intention. And that's it. And if it does, then the court can do what the court just did, which is strike it down and say, no, you have to respect the intention, and I think that's the key, the intention of the initiative. And I think we should put this in context of the Utah Constitution. It says there, the part of the Constitution they use, is that the people have the right to alter their government when they feel it is necessary. However, the people of the state of Utah do not have the power to initiate constitutional amendments. Only our representative functions have that power. So only the Utah State Legislature can initiate amendments to the Utah State Constitution. So then, any attempt by the people to enact permanent change via the initiative process has to be safeguarded by the Supreme Court, is I think what the Supreme Court's argument is. It can't be changed, otherwise the people have no recourse to changing their government or the law.
So you're saying the court feels to be clear, 26 states have initiative processes. Almost all of those have a process for passing constitutional amendments through an initiative process. Utah is one of just a handful of states that have an initiative process, a citizen-initiated process for passing statutes, ordinary laws, but not an initiative process for passing constitutional amendments. So in a state that had initiated constitutional amendments, you're saying the people could clear that higher bar, which usually an initiated constitutional amendment would require more signatures, perhaps a supermajority vote, other sorts of hurdles to be passed. But the people would have recourse to that sort of alternative process and then would be able to place it beyond the reach of the legislature because it would be in the Constitution. Utah not having that, the Supreme Court sort of filled the gap by saying if you're reforming government, then the initiative is sort of beyond the reach of the legislature in a particular way. Is that an appropriate thing for a court to do? To sort of fill that gap, to say, well, we don't have initiated constitutional amendments, We should find some way to give the people control over their form of government through an initiative process.
I'm not sure this is filling the gap so much as interpreting the Utah State Constitution in a specific way. So, for example, the Utah State Constitution has this really unique formulation where it reserves certain legislative powers to the people. So legislative powers are granted both to the legislature and to the people through the initiative process, which means that the people are retaining to themselves some power over creating laws that govern themselves. But they can't alter the Constitution themselves. So there has to be some method here, I think is what the Utah Supreme Court is saying, for the people to effectively retain the rights that they constitutionally have done so in terms of legislation.
That's very helpful. Ryan or Derek? I'll let you chime in.
Yeah. Oh, wow, that was a lot. I think there is an alternative, and that's elections. Right? I mean, you go into the founding of our nation and everything since then, and it was about creating a representative democracy. That's what ultimately the revolution and the founding generation were trying to create, as a government that represented them. And the same thing with the founders of our state. They wanted a government that represented them. And elections have always been talked about. You look into things like the Federalist Papers, that's the final recourse. That's the great check. Now, what makes this particular case interesting is it was about elections, right? Like the ballot initiative was about how we draw the districts that create, or that kind of set the rules, I guess, of elections in some ways. But even there, I think you've seen just in the last handful of years that that the boundaries, the political boundaries, aren't the limit on who can get elected. People thought, for instance, one reason why people thought Donald Trump would never win in 2016 was these kind of set views about what states elected or voted which ways. And I'm no fan of Donald Trump, but he did change things that way. And that same thing can happen here in the state of Utah if political players try to go that direction. And that's how our system is designed to work. And so to come in and say, for the court to say, that's not adequate, that's where I think you start to get this rub between representative democracy versus direct democracy, right? They're kind of pitting the two against each other as if they have to be, one has to be protected against the other, when ultimately they're both expressions of the power of the people and coming from that source.
Yeah, so let me formulate this into a question. Why aren't elections adequate as a method of doing this? Why not say, well, if the people are fed up with gerrymandering, the people are fed up with the way that we apportion legislative districts, if they want some sort of nonpartisan process, why don't they effect that through the existing electoral process, the legislature?
Well, yeah, so I'd love to respond to that. I think elections are adequate in a representative democracy that exists in the Platonic ideal. So if you were to sit down with a fifth grader and explain how representative democracy works, you would say, well, there's these people, they choose a representative, the representative goes and hopefully does the will of the people, and if he or she doesn't, those people have an easy chance to either complain directly to them or get rid of them. That's the theory, right? Well, let's consider all of the ways that our representative democracy gets distorted in practice and take Utah as an example. So first of all, start with legislative districts that are intended to separate and weaken the voice of minorities. Studies make it pretty clear that when you do that, you end up with representatives who are, number one, more extreme, and number two, harder to unseat. In other words, not accountable. Now my fifth grader is starting to get confused about why this is a good thing. Number two, what if you have a state where you've got one dominant power party, which of course is great because majority rule, right? But that party nominates all of its representatives through not a vote, but through a convention that is attended and where candidates are chosen by delegates rather than through vote. Now, you're not resolving anything through an election, but you have representatives who are answerable not as much to the people, right? But to a select set of party types who tend to be a little bit more extreme than others. What if you then add a legislative structure where most power, because of the extremism that is brought about through the gerrymander, is collected in the hands of just a couple of leaders. So I'm mad at my representative. I want to call my representative, and this is something you will hear very often. Honestly, I hated it, but I got to get my bills through, and I got to please leadership. So what am I going to do? There's one fourth distortion I'll hit quickly, which is an influence of money, right? Which I don't think was quite contemplated by the founders, and which also creates a significant distortion. Now, what is the answer, and why is it direct democracy? It's because in certain cases where all of these distortions multiply and they make your representative far less interested in you and more interested in moneyed interests, in leadership, in delegates, and in maintaining districts that don't actually properly aggregate the people, well then now we have a problem. And one good fix is to place a check on that legislature through direct democracy. Now, I think it's very interesting what the Supreme Court did here, because it did not say, legislature, you must defer to every initiative. That is not the case, right? The Supreme Court said there's a very interesting hybrid initiative where, number one, you rely on the constitutional right to an initiative, and that crosses over into the other right in the Declaration of Rights that says we have a right to alter and reform our government. When you have one of those, that particular kind of initiative should not be tampered with by the legislature because it's a government reform. And you can see the conflict of interest, right? When we're trying to reform our government, the legislature often will have an interest to say, gosh, we would prefer not. And so that's why it's an important check on elections. The other thing I would simply add is, in our representative democracy, which functions well in many ways, we never get the chance to vote on one issue. An initiative clarifies a question for the populace in a way that voting for my representative, who has 18 different stances and is also part of a big party platform, doesn't really do. And so an election for a representative or for a state senator or a federal senator is an aggregated and very blunt message that I get to send, whereas on one particular issue, maybe it's going to be harder to unseat somebody, and using an initiative crystallizes the will of a people in a different way that we typically don't otherwise get.
That was a rich comment. You've raised, by my count, about four different issues we need to tackle. So let me tackle one of them. You mentioned the scope of the Supreme Court's decision, and I think this is important for establishing just what that decision did. You said that it doesn't apply to all initiatives. So the Supreme Court's limitation on the legislature's power to amend or repeal an initiative only kicks in for certain kinds. Maybe, who wants to help me understand which initiatives are outside of that? So maybe the helpful thing to do would be to imagine what kind of initiatives does this not apply to, and thus the legislature is free to alter, amend, repeal them as ordinary legislation. And just to be clear, the basic principle here is, if an initiated statute is just ordinary law, like any other ordinary law, then a legislature can overturn it just like it can overturn its own previous statutes. So this has been the claim from the legislature in terms of the status quo on initiatives prior to the Supreme Court's decision was, we can overturn our own laws, any previous law, because no legislature can bind a future legislature. So Ryan suggested the Supreme Court's decision doesn't necessarily change that with respect to all ballot initiatives, but only some. So what would not be within the scope of this decision? What initiatives are still fully within the control of the legislature? Derek?
I think the most straightforward answer is we don't know. I mean, on its face, it seems like that creates some limits, but what I can guarantee you is every organization that wants to pass a ballot initiative is going to try to couch it in terms of we're reforming our government, and here's what the legislature is changing violates the fundamental purpose, right? Because that's what's going to get the Supreme Court to say what the legislature did to that ballot initiative is wrong. The issue is these are not easily definable terms that the court used. Reforming our government is going to mean some things to some people and something else to someone else, and they're all going to argue it means what we think it means, because folks who invest millions of dollars in ballot initiative campaigns don't want to see their laws changed. I mean, otherwise they wouldn't invest millions of dollars in trying to get them enacted. So this is kind of why this process is ultimately going to draw courts more into lawmaking, because if there's a significant reform and the folks who pushed a ballot initiative don't like it, they're going to sue and argue to the court that it was a violation of this decision.
So you're, people could, the lawyers, sorry, Ryan, could always make the case.
Compliment
that,
accepted.
That any, can make the case that any initiative counts as a reform of government. But I've heard examples like raising the drinking age, or just a change in policy, right? So it changes the law with respect to some policy issue as opposed to altering the government in some way. Can anybody else help me draw that line between an initiative that reforms government and an initiative that does something else that the law would do?
Let's let Savannah go, but I would like to share on this as well.
No, you go first.
Well, Supreme Court is, well, they're not novices, right? They took on this issue in their decision, and it was in response to an argument made by the legislature, which is, oh gosh, this alter or reform language, it's so muddy, what are we gonna do? And the Supreme Court said, come on. They kind of rolled their eyes. They said, have you heard of squishy terms like due process, or cruel and unusual punishment, or unreasonable searches and seizures? The basic nature of a constitution is not to elaborate legal tests. It's to provide a foundational principle. And that is exactly what we have with alter or reform. Using that verbiage, Supreme Court did what courts often do, originalist courts do, and it went back to original meanings. And it said, it was quite clear among Utahns who passed this language, and did so advisedly and very deliberately, that they knew what it meant. And they knew that alter or reform government is a bundle of tasks and a not bundle of other tasks. And their conclusion was to say, this is a term that is, and I quote, judicially definable. Do I think that it comes with clear guidelines? No, it clearly doesn't, but I would say that is not at all atypical for constitutional language. In fact, we litigate this all the time, and I've litigated language like this frequently, as we've been doing now for 200 plus years in this country, using constitutional language. And so I think the court would be quite defensive of this language, because it sent such strong signals to say it isn't everything and it's clearly definable.
Savannah, you give me more help on drawing the line between an initiative that reforms or alters government and other, whatever the other initiatives are.
I think this is maybe only confusing if you're a lawyer, actually. So, for example, an amendment, or not an amendment, an initiative to decriminalize marijuana in the state of Utah very clearly does not fundamentally alter Utah's government. That is different than an anti-gerrymandering initiative, which would give redistricting powers over to an independent commission. It is only a lawyer who would look at that and say, these two things are indistinguishable. But I think to the average citizen, you would say, they're very clearly of different types.
Okay. Even though there may be gray area. I mean, we can find some edge cases, but that was my impression too. Although I think we can find some gray areas pretty easily, like getting rid of a state-run liquor monopoly might be both. So we can imagine some very difficult cases that might come along. But in general, ordinary policy is a different thing that is making the laws that govern citizens. And I might suggest one way of thinking about this is, are you altering the policies that apply to individuals, to private citizens, or are you altering the way that institutions within the government relate to each other in some sense, or the scope of their powers? And that seems to me to be one way of drawing the line. I don't know if that meets with approval of legal counsel or not. Let's.
I do have a response to that, though,
Yes,
Matt. There are gray areas, and there's no way to get around those gray areas except that the court is going to weigh in a couple of times on this until we get a better sense. But when you ask Savannah about what kinds of initiatives can be changed by the legislature, fully correct answer. But there is one other thing the Supreme Court threw in, and that is to say, and I'll read the quote, legislative changes that do impair the reforms enacted by the people could also survive a constitutional challenge. How? If the legislature shows that they were narrowly tailored to advance a compelling government interest. So suppose there is an initiative that is passed, legislature wants to change the direct intention of it. It's possible if they can show, well, this initiative fundamentally strikes a major challenge at the core of how we govern, it's unconstitutional, or otherwise there's a compelling government interest, maybe budgetary, et cetera. And so there's no such thing as an initiative that the legislature cannot touch. It may touch everything, and if there's something that would, upend some significant governmental interest, legislature gets to say, have at it.
So I have a question about this. I'm glad you read this passage because the court does provide an out there. It says all of this sort of yields to legislative revision if there is a narrowly tailored means to achieve a compelling governmental interest. Now that language is very familiar to people engaged in the practice or study of constitutional law. It's familiar as strict scrutiny. It's developed in federal constitutional law to ensure that anytime you felt like you had a sufficiently weighty reason to violate a constitutional right, like if you need to, for example, engage in racial discrimination in some settings, say in the wake of a prison riot to separate a prison population, or if you needed to censor a press publication or otherwise threaten a constitutional right that normally is rigorously protected, you would have to satisfy this test of strict scrutiny. But that also, the phrase that sticks in my mind was Justice Scalia's phrase about strict scrutiny, that it was strict in theory and fatal in fact, that this test was almost impossible to actually meet, short of sort of life and death. Is the test that high? I mean, I've heard this has been a subject of some debate among advocates and opponents of the amendment and critics of the judicial decision. Just how high is that bar? I mean, is that a real... does that really leave the legislature much discretion? I guess another way of putting this is, what would be some compelling interest? I mean, what are some situations you can imagine where the people pass an initiative reforming government, altering something about its structure or the scope of its powers, and yet the legislature said, no, compelling interest, we're going to set that aside or modify that significantly. What would clear the bar?
Well, let me start with one, which is one that I've heard legislators use as a bit of a scary scenario, right? We, the citizenry, we pass an initiative that has dramatic budgetary effect, right? This is going to appropriate $500 million for this other purpose never contemplated by the legislature. And legislators rightfully say, gosh, we are constitutionally obligated to balance our budget. Can we not touch this quote unquote super law? Well, certainly you can, because that is an initiative that would set into motion unconstitutional realities, right? And the Supreme Court goes out of its way over and over to say, one thing you can never do by initiative is do something unconstitutional. If you want to change the Constitution, there's a separate process for that. And so I use that as one example, which is to say if there would be some large appropriation of money that the legislature says there's just not a way to balance this, I think that's a very clear compelling governmental interest that if narrowly tailored, their amendment would pass that scrutiny.
Did you have something you wanted to weigh in with here?
I think I'll just add, I think that's right, because it's in the Constitution, right, the balanced budget. And then you said if it's narrowly tailored. And that's oftentimes where these things can get struck down by courts, because what is narrowly tailored? Again, it sounds like straightforward. In fact, I mean, Savannah was saying earlier, right, these things make sense to the average person. It's just not to lawyers. But unfortunately, it's always the lawyers and people who are formerly lawyers who are making the decisions on these things, right? And that's who judges are. In fact, in Utah, judges who are nominated have to be approved by the Bar Association, or the committee, I guess it's called, that is largely attorneys. So these things get real very fast, and I'm not sure that I can recall. I'm not an attorney, right, so I'm not going to say I have comprehensive legal knowledge or anything, but I certainly don't recall an instance where the idea of a compelling interest narrowly tailored was invoked by judiciary to support a law. It's always invoked saying it violated that standard and struck it down, and that's kind of, I think, where you get Scalia's comment.
Let me rewind a little bit and go back to something that came up earlier and that we didn't get to flesh out. And that was Ryan's mentioned that ballot initiatives are a way for people to be able to address, for the people to be able to address a single issue. So legislatures are dealing with hundreds of issues, right? A legislative session has all sorts of things percolating. The appropriation of the public fisc and innumerable legislative issues. It's rare that the legislature can raise sort of one issue, take it all on its own, and say, is this a good or bad idea? And Ryan suggested the initiative process is a way for the people to take an issue of public moment, put it before the public, and be able to take sort of an up or down vote on this issue and disentangle it from all those other things. Is an initiative process the only way to do that? What's the alternative if we don't have an initiative process where the people can do this sort of thing? After all, only so 26 states have an initiative process. That means the other 24 have none. No way for citizens to initiate constitutional amendments or laws. They're totally reliant on representative institutions to do this on their behalf somehow. So I guess my question is, sort of bringing this to a higher level in terms of direct versus representative democracy, if you're not using an initiative process and those initiative processes are not protected from legislative infringement, how can you get a single issue in front of the public? And is that a problem?
Well, I mean, one thing that our legislature has done is to put non-binding questions before the people. You certainly have at the local level laws that with a city or county council or school district wants to do something, it also has to go before the people. So there are processes in place that kind of go through the representative processes to come before the people. I will say though that just to comment on something earlier that was mentioned about that, I don't know, I think it's a controversial thing to say it puts clearly one single issue before the people. Particularly I think the ballot initiatives that have been enacted in Utah, say in 2018, those were all complicated laws, and they had many facets to them. And when they look at the ballot language, it just by reality, by definition of word, by a limit of word count, had to ignore some of those elements in describing the law. So this is what the ballot initiative process looks like, is you have to decide what information goes easily before the people and what doesn't. What are you going to inform people and what are you going to not inform people of, unless they go and read the ballot initiative themselves. And not many people do that. And there's, I think, an open question as to whether that's a good process or under what circumstances is that a good process. Because certainly in the representative institutions, they spend a lot of time digging into things and having debates about it, and they hear from constituents all over the place. And so whether you like what the legislature does or not, and we don't always like what the legislature does, right? I'm not like a shill for the legislature. I think it's a process that brings information to the table in ways that the ballot initiative process doesn't by nature.
This actually raises a really interesting and fundamental question about this tension in American political development between a founding era that is deeply suspicious of the direct democratic process and creates a national government that is exclusively representative, and the progressive era, which is the era in which the Utah Constitution is written, which sees representative or exclusively representative functions as inadequate to getting the will of the people passed. So Utah creates, and it's fundamental to Utah's Constitution, a direct democratic method. And the idea is that the people can be trusted to be good enough citizens, to do their research, to be able to understand difficult questions such as, should districts be drawn by an independent redistricting commission? But that's the essential idea of the progressive era, is that the citizens can be trusted to do that. And then I think the second point is when we're talking about single issues before voters, I think it was less a concern that legislators can't handle just one issue at a time, but that voters get the chance to handle just one issue at a time. Instead of voting for a candidate because you have 27 different policies that you like and you're voting for a party instead of just on one issue, this simplifies it and allows you to vote truly as a single issue voter on that one item, something which is very difficult to do at any other time.
Yeah, it behooves me to mention that there's a sort of corollary to this in the founding, and this is appropriate on Constitution Day. Our Constitution's drafted by a representative institution, the Constitutional Convention, which draws representatives from, well, 12 of the 13 states. Rhode Island never showed up. They were just weird in the 1780s. They've gotten better since. But,
They were the Florida of the 1780s.
man, I am a Floridian. You know that, right? Okay, all right. I won't take it personally. I deserve it for all the knocks on lawyers. But when it came time to ratify, though, it was a very interesting decision that they committed ratification not to state legislatures, but to conventions selected for that purpose. And that's because those conventions would decide only on that issue. I think it is also interesting that this simultaneously recognized the need to put before the public a question: should we adopt this Constitution, and disentangle it from all the other partisan issues percolating around, disentangle it from the other issues the legislature has to deal with. At the same time, it was committed to a deliberative body. Even for ratification, we gathered in conventions for representatives of the people to then deliberate on the people's behalf. And if you'd taken a ballot initiative on the day that most of the ratifying conventions started about whether the public wanted to ratify the Constitution, our best guess is it'd probably be defeated. Because those ratifying conventions, people actually changed their mind. They were able to persuade each other, which really we know scientifically only happens face to face. No, people aren't persuaded typically by advertisements and other things. People change their minds based on personal interactions more often than not. So the founders had this sort of like sensitivity to the need to put an issue before the public, but still this deep suspicion of just putting it on the ballot as a question, because people might decide hastily. So I don't know if that triggers any.
Well, yeah, it does for me.
consideration.
Obviously, there's many things we do quite differently now, but there are some good reasons for how different we are now. Savannah mentioned the progressive era, and I wish we had a more neutral word for that era. We're not talking about modern-day progressives. We're talking about a significant movement driven by a political party, which involved people like Teddy Roosevelt and other luminaries at that time, saying, we have got to fix government and make it more responsive. Among the other changes they made in introducing tools of direct democracy was to elect our senators directly, which we didn't used to do. They made significant progress on keeping large moneyed interests out of elections, and they also, during that era, got women the vote. All of these things had the impact of moving power from elites, which is essentially what our founding was, down to more average and everyday voters. And here we are today with all these mechanisms now of political communication, much more widespread literacy and education, all of which suggests to me, and maybe others disagree, that we need to be trusting our electorate more on the ground rather than less. And what I would venture to say the legislature has been doing lately has been trying to shift that power the other direction, has been trying to say, we're going to keep this initiative thing in the Constitution. You guys can do what you want, but we would like it to be that whatever you do, we get to come in over the top and just cancel it out. That looks to me like the old school way of doing things, instead of just trusting our voters to make the proper decisions. And then, of course, there is the more controversial development, which is that they then granted themselves the ability for legislative leadership to draft the ballot language summarizing the amendment, and then drafted ballot language, which I think to most eyes, I'm going to recognize people disagree on this, was quite different from what the actual amendment language really did, and now has been found by a Salt Lake District Court to be void.
So that raises a question for me. Why is it that we don't just put the constitutional language on the ballot? That is, put the existing language of the Constitution and then the proposed language that would be inserted.
I think it's because we're wanting to simplify things for people, because I think whether it's stated or not, there's a general recognition that it's very challenging to read through all these things and make these decisions. For example, there was an author in the Atlantic, resident of a state, Oregon or California, where ballot initiatives are much more plentiful. railing against what ballot initiatives have done those states and describing the process of voting as an 8-hour research project. Who here will put 8 hours into voting, researching? A few.
The
Okay.
political science majors in the room.
Yeah.
All right, sure, I'll do that. Yeah.
Congratulations to all of you, by the way.
Yeah, exactly. But it's a small minority. And I would imagine here this audience is one who would be more interested in actually looking into things that way. And still only a handful are willing to put the time in to read through a whole law that they're having to vote on, which actually, again, isn't really going to be about a single issue. So let's pick an example. The Medicaid expansion ballot initiative in 2018. Right? Presumably it's about should we expand Medicaid? Seems straightforward. Then we have to initiate a tax increase to do that. So now it's also about tax policy. Do you think tax increases are good? And it's going to put people into a government healthcare program. So now we're talking about is free markets or government the best way to provide healthcare to people? There's no ballot issue that's a single issue. But we have to try to boil it down as close to that as possible because of this reality that people, for whatever reason, won't put in the time to do this. And I think this is why the founders preferred representative democracy, is they wanted deliberation on these things. And so when you elect people and put them all in a room and their sole purpose is to read these things, research them, hear from people, deliberate on them, it tends to happen more. And that's how it was designed.
Savannah?
A quick response here. First, I think we should be really wary of the argument that Utah will become California if Amendment D is not passed. Utah has had an initiative process since 1900, and in that time has not become California. And I was a California voter for 5 years, and it truly is awful. But Utah is not California. But second, I think we should go back to this ratification point that you make because it's excellent. A second reason you jump over the state legislatures in ratifying the U.S. Constitution is that why present a moral dilemma to those state legislatures? Why tell them, please vote yes on this new U.S. Constitution that will take away your own personal political power, because the states will lose power here. You don't put people in that kind of a moral dilemma. So you skip them and you go to ratifying conventions. There's an interesting corollary here to what the Utah Supreme Court has just said. Are you putting someone in a really tough moral dilemma in the state government if they can alter an initiative that would fundamentally change the Utah government and therefore reduce their own power to do things like gerrymander? Why put people in that kind of moral dilemma?
Maybe I can respond a little too, and those are very good points. I just want to say Utah has a really distinct initiative process. I printed out the packet today. This is from the Lieutenant Governor's office. It's about, I don't know, a 12-page packet on the 17 different steps you need to go through to get an initiative on the ballot. It's quite complex. It requires multiple hearings in multiple different districts. I'll just read one requirement, which is that the Lieutenant Governor needs to reject the initiative if it contains more than one subject. Granted, I concede to Derek that that's not always the easiest to enforce because laws are complex, but initiatives truly are limited by law to a single subject, and then of course sometimes there's ancillary issues. But Utah it just can't be California. The process in California is notoriously easy to get on the ballot. You need 2.4% of voters to approve to get your ballot initiative on the ballot in California, and there's no geographic requirement. In other words, if I go knock doors in Fresno and I get everybody in Fresno to agree, my initiative's on the ballot. That's it. In Utah, you need to go get 8% of voters in 26 of 29 different state Senate districts. It's far more onerous. And so now you think about how many times you've actually voted on one of these things. Well, California since 2000 has had 218 initiatives on the ballot. Since 2000, Utah has had 7. Again, we are not in danger of overwhelming our voters with this informational overload and decision paralysis. We keep things succinct. It's a hard road to walk through. And then maybe it's a little justifiable that once we walk through all of those hoops, people get a little angry when the legislature says it was all for naught.
If I can just add
Sure.
really briefly. Of the ballot initiatives that have happened, was you said 7 since 2000? Half of those have happened in the last 10 years, right? About 3, so a little less than half. And that's because the process of getting things on a ballot, whether it's someone running for office or a ballot initiative, has become systematized. Won't go into all the details, but it has to do with Count My Vote, and that process was put in place over a caucus convention versus primaries. The point is just to say, after the Supreme Court ruling, you had folks quoted in the press who are involved with ballot initiatives saying they're going to start recommending people do ballot initiatives here in Utah, whereas before they said don't do it because of these challenges. But that court decision changed the rules of the game. And so are we going to become California? I don't know. Are we going to become more like California? I think so. I mean, when the people who actually do these things are saying we should do more of them under these rules, it's hard to say that we're not going to go in that direction.
So is the rationale there is that it's just a bigger prize? I mean, it's not that the process hasn't gotten easier.
Correct.
So it would have to be, if it's movement in the direction of ballot initiatives will become more common, move a little closer to states where these are the sort of, way of doing business, it would simply have to be because it's a more valuable prize now.
Well, that plus it is, whether you want to say it's easier, it's less complicated. Prior to that, you basically had to go and get a whole army of volunteers to go gather signatures. Now, if you pay a company to do that for you, which is kind of a systematized process, and you have enough money, you can pretty much get a lot of, well, I don't want to say anything, but you can get a lot of things on the ballot nowadays if you have the money. And this is why folks turn to out-of-state operators to do this, which is oftentimes you get a significant amount of out-of-state money coming to support these ballot initiatives because that's where the money is. And so it's going to be more plentiful because not only is it now more straightforward due to the kind of the systemization of the process, but yes, now you're more protected. If you structure your ballot initiative in a way that you can argue credibly legally that it's a reform of the government, and if you can argue that any change is not narrowly tailored to a compelling interest, then you have a fighting chance to overturn anything that the legislature might do. And again, this is what attorneys, in politics at least, what attorneys do for a living is kind of craft these arguments, insert this so it's more of a government reform, even though it's not really connected to the thing you really care about. You know what I mean? This is what the strategizing is going to be under the new kind of rules the Supreme Court's put in place.
I would just say, Matt, in response to that, I would like to know who these people are because they don't strike me as super intelligent. If they think that they will be able to come in and initiatives will be easier to get on the ballot and then passed and then stand up against the legislature, unless they're all trying to actually reform the Utah government. As the Supreme Court has made very clear again, if you're coming here to Utah to try to get cannabis for everybody, or abortion on demand, or whatever the scary thing is, right? Nothing has been changed by this Supreme Court decision. The legislature maintains full power based on what we've seen today to strike that down. I guess I would just, I also want to add, one of the things the legislature claims is driving this is an influx of out-of-state money. I won't deny that initiatives are often funded in part by out-of-state money. Now, again, it's not the same thing as legislation that is passed by out-of-state money because we're again talking about reforming our government, and there's just not a lot of people who have business conflicts that relate to reforming the Utah state government versus, I gave money to the legislature because I'm big pharma or some other business interest, and that drives my interest. But it's important when we think about the legislature and the people as checks on each other to think about money on the other side of things, which is the legislature. Where is their money coming from? Well, the numbers are a little bit discouraging. President Adams, President of the Senate, in the 2022 cycle, 41% of his funding came from out of state. Mike Schultz, the Speaker of the House, 34% of his funding came from out of state. The Salt Lake Trib did an analysis in 2018 that said 82% of funding for our legislators' campaigns came from either out of state or from special interests. Well, is that wrong? Do I know the answer to that? I don't. But you shouldn't have a system that doesn't allow foreign money to come and support people's initiatives, but allows this massive flood of money to support legislature campaigns, which often end up, pushing back on the right of the people to reform their government.
So let me turn our conversation in a little bit of an institutional direction here. We've got some problems that we've been trying to solve with initiatives, or problems, I should say, that initiatives are supposed to solve with the Republican government. I'm curious about the way initiatives are written. So we were talking about the ratification of the Constitution. There you've got a constitutional convention writing the Constitution, and then you have a separate body that ratifies, right? There's an ordinary legislative process. You have a legislative body that both writes and ratifies, in effect, right? It's engaged in the drafting, the proposal of the bill, so to speak, and then the up or down vote at the end of the legislative process that says, yes, this shall be law, and then in many places, some sort of executive veto is added to the end of that process. Thinking about this in terms of ballot initiatives, what is it about the ballot initiative process, or how can we in a ballot initiative process make sure that the language of initiatives are carefully crafted? That is, how can we bring the virtues of legislative deliberation to bear on crafting initiative language, in part because, by one light, you'd say, well, who writes the language of the initiative? They're writing the text of the law to be adopted. Should that process be representative? How can it be representative? Is it necessarily just driven by whoever's initiating, that is more often than not, the special interest or the firm that's been hired to help craft the language? Is there any concern about that process, or how do we structure that process to make sure that when we write those laws and recognize that these are laws that could be adopted as the law of the state? So how do we bring the principles of Republican government to bear there? How do you responsibly write an initiative that's going to be put before voters?
It's a really good question. It's actually something that we've started to think about, because let's assume that the district court decision gets approved by the Supreme Court, and regardless that this is just how it is moving forward. It's a really valid concern. I won't mention the ballot initiative because it might identify the person, but having talked to someone who drafted one of the ballot initiatives in 2018, he'll openly admit, yeah, I wrote it in my basement. Right, there was no real deliberative process going on. And this is a smart guy, right? I'm not saying he just some rando or something like that. But the question is that the process how we want our laws drafted? And I think, certain ways you could do this is to potentially lengthen out the timing between when an initiative gets enough signatures to get on the ballot and when it appears on the ballot, so as to provide deeper analysis, perhaps by the same folks who analyze legislation, finding things that then maybe create some kind of amendment process before it ever shows up on the ballot to clarify things like things that are unconstitutional, things that violate federal law, or whatever it might be that need to be a little more deliberative than is currently the case.
I would say that we have a fairly robust system for this, both de jure and de facto, right? The first is that the initiative process actually has written into it a structure for this. If I'm going to get an initiative going, I need to write the text. Maybe it will be in my basement, might be somewhere else. But I need to provide it to the lieutenant governor's office. The lieutenant governor will then do a review. They will reject it if it's unconstitutional, if it is nonsensical, if it treats with more than one topic. Nice little check there. After that, I need to go and do multiple public hearings throughout the state in which public comment takes at least 1 hour, right? And so there's a nice check there. The next step says optional, revise the text of the initiative and resubmit. And so that is written into this system. Now, that's what the law requires, but let's talk more in terms of how things work. The legislature is in the room more often than not in the crafting of so much of this language. I know of a handful of initiatives where legislators were consulted, were part of different hearings, and there was a process, and so that, there is the right level of competency and professionalism in drafting, et cetera. I guess the final point I would make is that let's say we do end up passing an initiative that has a kind of a wonky, nonsensical thing. Well, Supreme Court has expressly empowered the legislature to come in and take that piece out of it so long as it doesn't impair the original core intent of that legislation. Now, your idea about a representative process for drafting an initiative, that's fantastic. I love the idea. A little radical and maybe hard to implement, but we ought to think about other ways to do this. But I do think there are a lot of checks to get to streamline and professionalize language as it goes through this system right now.
Actually, I'd say we've got a process we've used hundreds of times for doing this. It's how Americans have traditionally written and significantly altered their state constitutions. And we typically do it through constitutional conventions. So I guess this is one question I sort of selfishly would like to pose to the panel. Is I've been thinking about this as this controversy has been going. I've been thinking about, my own, the center is engaged in a lot of scholarship on constitutional conventions and constitution making. And actually got to thinking about the fact that Utah lacks an initiative process for constitutional amendments. And I thought, well, let's assume I take the founding generation seriously that maybe doing this through direct democracy is not a great idea. How would you shape a representative process to sort of take on the writing of laws or take on constitutional amendment? And I thought, well, we've got a way to do this. We have constitutional conventions that meet. The question is how to initiate them. And I wonder about an initiative process that would allow the people to call a convention to address an issue. As you can put on the ballot, shall there be a representative convention to address the issue of redistricting? And then you'd have to have an electoral process to choose a representative from the various districts. I guess you'd be stuck using the existing House districts. But at least you wouldn't be stuck with the legislature, right? You'd have the separate deliberative body, and that's a robust American tradition that it seems to me to marry this concern with the need for the people to initiate a review of its laws or initiate change and disconnect that from the legislature, but still keep the benefits of representative democracy. Thoughts on this? I mean, are there other ways to make sure that an initiative process is responsible and taking account of the various interests in a state?
I actually think this is a great idea, but only if you buy into the idea that, in fact, direct democratic methods are bad for the country. That's kind of the thing you have to believe at this point, which is fine. That's the founding era idea, but again, it's not the context that the Utah State Constitution was written in. I'm not sure Americans still believe that today, that it is more dangerous to allow the citizens to vote directly than it is to allow legislators to have full control over this. But you have to answer that question first. Is it actually a bad idea to let the people do it? And then second, just to go back for a quick second, I think maybe we give way too much credit to political elites. We talk about the guy writing an initiative in his basement, but in Utah, which I think is brilliant, we have normal people in our legislature. We're not doing well with this word today. They have part-time jobs. I know a guy who works in the legislature who owns a bakery. They're the ones writing legislation in this country, or in this state. They're also regular Joes. They could, for all we know, have done it also in their basement. And there's a process for both of these to make sure that the legislation comes out making sense. There's a deliberative process, as he walked us through, for the initiative and the guy who wrote it in his basement, and for the part-time legislator who may have also written it in his basement and who had checks via the deliberative process in the legislature.
Well, I like the idea myself. I think the biggest concern I have about initiatives is kind of the relative to representative democracy, the lack of really thorough deliberation that goes into the drafting and changing and ultimately what finally ends up as the law. And this would seem to address that at some level, having vote for someone in your community to go debate these things. I just responded quickly to something Savannah said, that a legislator is in charge of a bill, but the legislator doesn't draft the bill. They have attorneys that draft the bill. And while they're responsive to the legislator, I'm not sure I've ever seen a bill where a legislator came and said, "Oh no, I drafted this. The attorney had nothing to do with it." That's not how that process works. So I just want to make sure that's kind of understood as to how that process actually functions.
I would add, though, that to Derek's point about systemization of initiatives, that's also the case, right? Better Boundaries has very competent legal counsel, as do some of these plaintiffs who have now secured some nice litigation wins. I don't think we're going to be dealing now with initiatives that get very far, that are not fairly well thought out and crafted. And I'm not aware of an example that was just totally shoddy. I actually know that the Better Boundary, the Prop 4 had a couple wonky elements that got kind of hammered out as there were discussions going forward, and I would expect that to be the case typically. I would geek out at the idea of a constitutional convention, and I think there's real upside to that. I don't know how wide open you open that door, but it could be a nice solution for many things.
Yeah, it terrifies people, actually, and legislatures especially. I do want to turn, before we run out of time, to the question of where we stand with the controversy, actually. Just to review, we had, in 2018, Proposition 4 told us to create a redistricting commission, set some boundaries on the kind of criteria that they could use, told the legislature that if they departed from it, they needed to explain that. The legislature then enacted SB 200, right, which partially implemented that. It did create a commission, removed the ban on partisan gerrymandering, and ignored the requirement that they explain their reasons for departing. The legislature subsequently adopted its own map instead of the one proposed by the commission. And then the litigation has ensued, right, which ended in the Supreme Court. We could say in the Supreme Court, at least, let me think of the least controversial language to describe this, the Supreme Court describing what the court takes to be the outer boundaries of the legislature's discretion over a ballot initiative after it's passed, and cabined that discretion whenever it comes to ballot initiatives that reform government. So where we stand now, the legislature met in emergency session, proposed Amendment D, which would put some language into Article 1, Section 2, which I read earlier, making clear that that right to reform government is through the processes described later in the Constitution, is the initiative process described there, and then in that provision explaining that that doesn't foreclose subsequent legislative action. In other words, ballot initiatives, just ordinary laws, the legislature can treat them like ordinary laws. So that's sort of where we stood. And now the district court has suspended the amendment and said that the lieutenant governor's office should not count votes on that amendment because the summary on the ballot the district court took to be an inaccurate summary of the law, misleading summary of the amendment. So that's where we stand. So what happens next? Anybody want to help me out with where we are? What happens now?
Yeah, so the legislature has appealed to the Supreme Court, Judge Gibson's decision. Unless something crazy happens, we will get a decision from the Supreme Court within, I would say, a month, because we've got to know what's going to happen going into this. The language of Amendment D and the ballot title, they call it, the descriptive language, will end up on the ballot. And so should the Supreme Court decide to overturn or reverse this district court decision, we're all going to go vote on Amendment D. Also a strong chance, I think, the Supreme Court rules the other way and says we are going to uphold Judge Gibson's decision. There was a significant piece of this amendment omitted from the ballot title. Therefore, it is void. You can vote on it, but the votes won't be counted. That doesn't tie the hands of the legislature to make another run at this, right? I don't want it to be overlooked that the district court also said that this is void for a separate reason, which is that the legislature just overlooked a key component, well, a requirement of amending the Constitution, which is that once you propose an amendment, you need to list the language of the amendment in a newspaper in every county of the state 60 days before the ballot, before the election. They just didn't do that. And so we've got a really technical problem here. I'll be interested, but it's hard for me to see how the Supreme Court overlooks that. But again, there are more elections to come, and the legislature remains in power and will have another run at this if they want to make it go.
So let me ask this of the other panel. Would Amendment D restore the status quo? Or would it, in other words, move back to the status quo on initiatives before the Supreme Court made its decision? I guess that's sort of the modest position. Or does the amendment do more than that in altering the initiative process? Does it give the legislature more authority than it would have had if the Supreme Court had never taken up this question?
The latter, I think.
Okay. In what
I'd say the
fashion
former.
does it increase the legislature's authority, I guess, would be the question.
It increases the legislator's authority by significantly decreasing the independence of the initiative process. I think that's the key, is in that balance between who gets to control legislation in the state of Utah, which again is split between the people and the legislature. It now heavily favors the legislature as the final arbiter of all law in the state of Utah.
Okay. Derek, you had a different take on this?
Yeah, I think it's the former. Just in observing how the pushes for ballot initiatives have operated in the state, oftentimes after they were enacted, they ultimately worked with the legislature on amendments, recognizing that the legislature could ultimately choose to appeal or repeal if they really wanted, but certainly could amend significantly what was on the books. So I think it's always operated that way, and that's what it will go back to. And that's kind of what the legislature tried to signal, I believe, when they also enacted enabling legislation, right, that would say that the legislature, their guiding rule would be they aren't going to override the purpose of a ballot initiative that passes, but they will reform them for constitutional reasons, budget reasons, those kinds of things.
Matt, there is helpful language in the Supreme Court decision on that question of what was the status quo. And I want to say this was after a fairly scholarly historical review of what did we all think it was at the time. They wrote, the people took it as a given at that time that when the people spoke through an initiative, they would have the final say on the matter at issue due to the people's inherent sovereign authority. Such sentiment is demonstrated in statements that direct legislation would empower the people to, quote, hold the final verdict in their hands. So based on their historical analysis, they concluded unanimously in a fairly well-researched and scholarly opinion that the status quo was, in fact, that the people would have the final say.
So the other states that do this, about, I guess, 10 of the 21 states have initiated statutes, put formal limits on the legislature subsequently. 8 of those have supermajoritarian requirements. The legislature wants to repeal or amend, they have to do it with a supermajority or they have a waiting period. And then 2, California and Arizona, don't allow the legislature to make any changes, but instead direct the legislature to submit proposed amendments to a ballot initiative to voters at the next election. I guess the question would be, if in fact those limitations exist on the legislature and in other states where they exist, they're formally part of the initiative process in the Constitution. I guess why was this left so vague in the Utah Constitution when other constitutions were much more specific about it, about those limitations on subsequent legislative change?
It's an interesting question. I'll give you the answer from the Supreme Court, which is that Nebraska was the first state to pass their constitutional amendment allowing initiatives, and they did include a legislative override. Utah came not long after that and did not. Typical judicial analysis would be to say, well, that option was available, it was well known, it must have been considered, and then was probably consciously rejected. That's their take on it.
I am afraid that we've run short of time on the panel. I've enjoyed this discussion. I want to thank all of you for joining me and helping us think through this issue. I want to thank our audience, both live stream audience on YouTube and our live audience, for being here and engaging this issue with us so thoughtfully and trying to shed some light on what's become a very difficult, obviously complex, but pressing issue that both the public and our political institutions are going to have to address. I will say in closing, if you found this helpful, if you found this event helpful and informative, please look at our website, uvu.edu/ccs, and our associated YouTube page. As I mentioned earlier, this Constitution, a podcast for We the People about their founding document, will go live later this month. So be looking on your favorite podcast platforms for that. And I hope you'll all welcome me or join me in thanking our panelists.
Thank you.